first case to come before the court is State versus King. Both parties are ready to proceed. We're ready to hear your arguments, and you each will have 15 minutes, and you may reserve up to 5.
Thank you.
Thank you.
I'd like to reserve 4 minutes.
That's fine.
Good morning, Your Honors. There are 2 assignments of error in this matter. The first is that the trial court erred in allowing improper authentication of a video evidence, of a surveillance video. And second, that the trial court abused its discretion in admitting hearsay testimony. The facts of this case are, it was a jury trial here in Lorain County. There was a controlled buy of drugs. The officers equipped a confidential informant with audio and visual technology, sent her into a vehicle, a Jeep. A transaction occurred. She came back to the officers. The controlled buy money was never found, and Mr. King wasn't arrested until later. And also that Jeep was not in Mr. King's name, was not registered in Mr. King's name. The first assignment is the authentication of the video evidence. The admissibility is it's governed by Evidence Rule 901A, which states that the matter, there must be evidence that the matter is what it purports to be, or what the proponent claims it to be. The video here is sort of a video of the confidential informant walking up to the Jeep, getting in the Jeep. It's not a real clear video inside the Jeep, and then coming back to the car. The state makes an argument that in their brief, that the video, that it was, the technology was placed on the confidential informant at the detective's discretion, that the detective never lost sight of that confidential informant, and that they could listen in real time. They didn't view, the detectives didn't view it in real time. And the state also points to Hoffmeyer, which is a decision out of this court, the 9th District, in which an officer was able to testify or authenticate a video that he viewed of a Sheetz parking lot, that there's a crash there. And in the Hoffmeyer decision, there's also a reference to Freeze, which is not in the 9th District. But in the Freeze case, there was a series of robberies. The third robbery, there was nothing to authenticate the video other than the officer's testimony. And in that case, the court allowed the officer to authenticate it. And the difference between these 2 cases, in the Freeze, that third video, the officer was able to go to, they used a neighboring business surveillance, and he was able to go to that scene, view it, and say, yes, this is what the video is what the state purports it to be. That's an accurate description of that area. And in Hoffmeyer, same thing. They were able to observe the crash, look at the Sheetz parking lot, and again, confirm that that was what the authentication was able to authenticate, that that's what the state had reported it to be. In this case is a little different because the detectives were never inside that Jeep. So where the actual crime took place, it's not a crime to get inside the vehicle. Where the actual crime took place, there was no evidence that that Jeep, inside the Jeep, is where what the state reports it to be. So there was no testimony to that effect. The officer did testify that he never lost sight of her, but that he couldn't view the actual transaction. It was below the windows where he couldn't have seen. And there's also a decision of Bell, which is out of the 3rd District, and it sort of deals with these videos and whether if you can listen to them and, and whether that's enough to authenticate the video, listen in real time. Again, that decision's not out of this ninth district. I guess I'd ask you to disagree with that decision, because if you look at the actual, I kind of think about it as this long video, and if we were to crop it to that, where the actual crime, took place, that box of time inside the vehicle, there really is no evidence that that portion of the video is, what the state is saying that it is. There's no one else was inside that vehicle besides a confidential informant who wasn't able to show trial, didn't show a trial. State wasn't able to locate her. The second assignment of error deals with with hearsay evidence and statements that the confidential informant had made to the officers and during the course of that video. And again, she didn't show for the trial. They weren't able to locate her. So I think we all know what the hearsay evidence is. In my brief, again, states that the hearsay evidence was admitted in violation of the 6th and 14th Amendment and the Confrontation Clause. And the biggest thing here is that the state didn't put on any evidence that there was any effort to locate the witness and that she wasn't unavailable. They said they were unable to track her down, but that doesn't necessarily meet the requirements of unavailability. They didn't put on the record any evidence that they made an effort to locate the confidential informant. The hearsay statements were as far as identification of the defendant in the car.
That last point, the hearsay statements were related to the identification of the defendant in the car. She doesn't get in the car and go, "Hello, Mr. King, good to see you again." I mean, I'm trying to figure out how he was not also identified by the police officers, because they were, there at the time.
Right. Well, she does say something to the effect of, "Oh, it's you," and that taken with earlier testimony of text messages in which she tells the officers that I'm texting Ean King. And that was also admitted that she had told the officers that I'm texting Ean King. That, I guess those two combined would be the identification hearsay statements.
Because as it relates to the audio portion of that tape, and trying to figure out if that was offered to prove the truth of the matter asserted, that's where it's kind of breaking down a little bit for me in terms of whether or not it was hearsay. Now, I understand the tandem confrontation argument, but was there any sort of, was this a bench trial?
It was a jury trial.
Jury trial, okay. Was there any sort of, I didn't get from the briefs, was there any sort of limiting instructions about anything and no redaction of anything?
There were not, no. And like I said, I guess the statement in the video was, "Oh, that's you," and taken in, together with the prior, what I would say is a hearsay statement of, the officer said, "Oh, confidential informant said that she was texting Ean King," and those two together identify him as the person in the car.
And then he took the stand, right?
He did take the stand.
So it wasn't, and his defense was, "I don't know anything about it," wasn't it?
Correct. I'd like to reserve the rest of my time.
Thank you.
May it please the court, my name is Natasha Guerrero, and I represent the county of the state of Ohio in this matter. The state would assert that in this matter, the trial court properly allowed the jury to consider the controlled by video because it was in fact properly authenticated by Detective Constantino, and because any statements made by the confidential informant contained within the controlled by video were not hearsay and therefore did not implicate the Confrontation Clause of the Sixth Amendment. With regard to authentication, that is a threshold issue before any evidence is admitted or can be admitted at trial. And any person with any sort of personal knowledge of a video, its contents, has the ability to authenticate a video if they are able to testify that it fairly and accurately depicts what is contained within that video at the time that the events were transpiring. And I did cite within the state's brief, State versus Bell, which did deal with a control, or actually two controlled buys. And in that matter, the detective was able to testify as to his personal involvement with the controlled buys, about placement of video and audio surveillance equipment on the confidential informants, and actually personally placing it on the confidential informant during that second buy. He was also able to testify that although he was not right there when the buy took place, he was able to hear everything that was happening in real time through the audio of that surveillance equipment. And as well as that operation was actually at his, was taking place at his command. He was the lead detective in that matter. And the state would submit that's very similar to what we have here. Detective Constantino was the lead in that particular, in this particular case. He testified that prior to the buy, he did meet with a confidential informant, went through pre-buy precautions of searching her, making sure she didn't have any sort of contraband, weapons, drugs, anything of that nature on herself or in her possession. He actually personally placed the video and audio surveillance equipment on the confidential informant and was able to testify during the video that the time frame that he actually placed it, he was able to identify himself in the video, actually going through the process of placing that on to the confidential informant. He did testify to maintaining that visual surveillance of the confidential informant, hearing everything that was happening in real time through that audio surveillance, as well as after the buy, the CI came directly back to him, and it does show him again in the video taking off that surveillance equipment again, so he's able to identify himself on both ends of that particular video. And although obviously he wasn't there, he's able to personally identify that front and end portion and everything he was able to hear as was taking place. And actually during this buy, they thought that the buy was going to take place in a parking lot that was across the way from where they were parked, so they were parked in an opposite parking lot to be able to see everything. And the vehicle actually, he was able to see her get into the vehicle, and the vehicle actually came right in front of their vehicle and parked almost right behind them, basically. So the buy was taking place within 50 feet, I believe he said, of their actual vehicle. And during that time, he was able to identify both the confidential informant as well as Ean King in the actual vehicle, and he was able to identify Ean King in the surveillance vehicle as well. Therefore, the state would argue that, in fact, he was able to properly authenticate the video in this matter, because he did have personal knowledge of the things that were happening prior to, and able to identify all of that within the video, and also immediately after what took place in the vehicle when the buy took place. And in reference to Hoffmeyer, that was dealing with a situation where the officers were only able to identify and authenticate a portion of the video that happened directly after the crash took place. They were able to say, yes, the vehicle was where I saw it to be. One of the officers was actually able to identify himself and his partner in the vehicle. And in that case, this court found that because the officers were able to authenticate at least that portion of the video, the jury was able then to infer that because that portion of the video was correct, that the portion of the video and events that transpired prior to that could also be properly inferred as being authenticated as well. So that was what our reference was in regard to Hoffmeyer in regard to the first assignment of error. With regard to the second assignment of error, there are several cases in which state that videotapes of a controlled buy are not hearsay and do not implicate the confrontation clause. That's out of the 8th district, the 3rd district, as well as the 3rd district cites to several federal districts as well, federal courts as well. In that, the statements of the confidential informant in the video are offered with regard to provide context to the defendant, responses to that particular confidential informant, and not with regard to the truth of the matter asserted, and therefore is not hearsay and does not implicate the confrontation clause. And with regard to that, there is a case out of the 2nd district by the name of State versus Ali, and that again is also dealing with the situation that we have here, being controlled buys. The confidential informant did not testify. However, the detectives that were involved with those controlled buys were able to testify to their personal knowledge of what took place. They were able to testify to the pre and post buy precautions that were taken. They were able to testify to their familiarity with the defendant. And based upon all of those factors, the court there was able to determine, or did find, that any statements by the confidential informant in that matter were not hearsay because they were just providing context with regard to what was going on with the defendant there. And the state would argue that that's the same situation that we have here. Again, Detective Constantino was able to testify to pre and post buy precautions that were taken, that he was the one who provided the video surveillance equipment, audio surveillance equipment. He was able to listen to everything that was going on that was happening. And he was also able to identify the defendant within the video. Therefore, the state would request that is here, as with the other cases out of these other districts, that this court find that the statements contained within the actual video by the confidential informant were in fact not hearsay, did not violate the confrontation clause, and therefore that the trial court did properly admit the video in this matter because it was properly authenticated, and the statements contained therein were not hearsay, and would request that this court uphold the decision of the jury and sentence issued by the trial court. Thank you, Your Honors.
You have 5 minutes.
As far as the first assignment there in the authentication, I guess it's true that any person with knowledge can authenticate a video, but again, taking that larger video and looking at when the actual crime took place, there was no evidence of anyone with knowledge during that time when the crime took place. There is, at the beginning and the end of the video, the officers were, even in the video, could observe and hear during that time, could see everything, but they couldn't see, the actual transaction, the actual crime take place. In Hoffmeyer, they could observe, later they could observe what took place. There's never any evidence of anybody that had been inside that Jeep, that was an accurate video of the Jeep and inside the Jeep and where the crime took place. As far as Bell, again, I would agree that the facts are similar, but that I would ask you to disagree with the 3rd district on that regard, because again, if you look at under that theory, anybody could authenticate a video if they viewed it after the fact. That they could, as long as it was one of these confidential informant videos, they could later view it and say, yes, I viewed that, and it's what I viewed, and yes, I can authenticate that, and they could get up and testify. The second assignment of error in the hearsay, the cases cited by the state and that say that typically these confidential informant videos are provided for context matters and therefore not hearsay. That's true, except for in this instance, there was an identification to a certain extent. And there was also talk and I guess this goes to the question earlier about whether the video was redacted in any way. There was talk by the trial court of viewing that video prior to the jury viewing it and redacting any hearsay statements, but that was never done. There was sidebar discussion. The trial court, I believe it's in around page 100 to 110 of the transcripts, the trial court never did that and never viewed it to see if there was the hearsay statements, and that he could redact them before the jury heard them. So I'd ask that you reverse the conviction for the reasons stated in the brief. Thank you.
Thank you both for your presentations to the court. The court will take the matter under advisement. We will issue a written opinion